benefits and not to be considered salary under Article 14 BIS, and therefore cannot justify a unilateral termination. Members of this tribunal, we recognize the concern and frustration of the respondent over the non-payment of performance bonuses. However, the proper records was for the respondent to invoke Article 12 BIS of the FIFA RSTP, which provided the appropriate forum for overdue payables and includes sanctions such as fine, money, but never termination of the contract. The respondent did not follow this route, but instead unilaterally terminated the contract without just cause. This concludes my argument on issue 2. If there are no questions from members of this tribunal, counsel would like to yield the floor to our co-counsel to address issue 3.
That is fine, but just to note, the questions will come after the conclusion of your submission. So we just want that you flow, and then we'll come in later.
Okay. Much obliged, Mr. Arbitrator. Honorable Tribunal, as earlier introduced by my co-counsel, my name is Esther Ojo, and I'll be canvassing arguments on our third and final issue, which relates to the appellant's entitlement to compensation. Honorable Tribunal, the facts before us are as clear as day. As we can see in paragraph 16 of the moot facts, the respondent unilaterally terminated the employment contract. And as my co-counsel has established in our second issue, this unilateral termination was done without just cause. It is on this that we submit that the appellant is entitled to compensation pursuant to Article 17(1) of the FIFA RSTP. Honorable Tribunal, we deeply sympathize with the position of the respondent in this particular case. If we wanted to take him back to the club, and this is just based on assumption, if we wanted to take him back into the club, we are precluded by CAS jurisprudence. As the panel held in the case of Wisla Krakow versus FIFA, and also the case of FC Nantes versus Al Nassr Sports Club. The panel stated, any circumstances which, according to the rules of good faith, mean that the party who has given notice of termination cannot be required to continue the employment relationship shall be deemed good reason. And also, it has been held by the panel in both cases that where a party has unilaterally terminated the contract, is not obliged to return and remain in the employer's stead to render its services. It is on this that we rely on Article 17(1) of the FIFA RSTP to plead compensation because of the loss of the respondent services due to his unilateral termination of the employment contract. Making recourse to Article 17.1, 3 key elements can be seen. First is the law of the country concerned. Second is the specificity of the sport. And third is any other objective criteria, which include the remuneration of the contract, the remaining duration of the contract, whether the breach occurred during the protected period. We are relying on Article 17.1, but we buttress this position of the law with 2 important past precedents. First is the case of Wigan Athletic versus Webster and Hearts, and the second is the case of Cabezas versus FC Lugano versus FIFA. In the case of Wigan Athletic versus Webster and Hearts, the player was found to have unilaterally and without just cause terminated the employment contract, and the residual value of the contract was seen as the basis for the calculation of compensation due to the club. Honorable panel, I will quote the decision of the panel as seen in paragraph 86 of the decision in Wigan Athletic versus Webster and Hearts, and can be found on page 95 of the appellant's memorial. The panel stated, and I quote, just as the player would be entitled in principle to the outstanding remuneration due until the expiry of the contract, in the case of unilateral termination by the club could also be entitled to receive an equivalent amount where the unilateral termination has been done by the player. Moving on from that particular case, in the case of Cabezas versus FC Lugano and FIFA, the player argued that the club was not entitled to compensation as no financial expenses such as transfer fees or recruitment costs had been incurred by the club. To this, the panel rightly disagreed and said that even in the absence of any financial outlay, such as any form of other expenses, transfer fees incurred by the club, and the investment of the club is fraught with unjustified termination on the part of the player, the residual value of the contract remains the concrete means by which compensation is calculated. In applying these principles, Honorable Panel, we submit that there is no evidence that Mr. Ned signed a new contract and thus mitigated any form of loss, as to making sure that the residual value should not be the only should not be the only means by which the compensation should be calculated. And that based on Article 17.1 and still relying concretely on the case of Wigan Athletic versus Webster and Hart, the residual value of the contract remains the only justifiable means by which we are seeking this compensation. To calculate this and make this clear to this tribunal, Mr. Ned Kikomeko was set to earn 1 million naira per month. And based on the unexpired term of the contract, counting from October 20, 2024 to August 14, 2026, when the contract was set to expire, there is a duration of 23 months. Multiplying 23 by 1 million gives us a figure of 23 million naira. We believe, members of the tribunal, that this calculation, and based on the facts before us, based on the law and based on cash jurisprudence, that the appellant is entitled to compensation. This reflects legal fairness and protection of contractual stability. If there are no further questions for Mr. Arbitrator, counsel would like to move to proceed to give the appellant prayers for relief. Much obliged. The appellant respectfully.
Yes, you can proceed. Go ahead and conclude.
Right. Much obliged, Mr. Arbitrator. The appellant respectfully requests this Court of Arbitration for Sport to grant the following reliefs. First, that the FIFA DRC lacks jurisdiction to hear this matter at first instance, and that the decision of the FIFA Dispute Resolution Chamber be set aside in its entirety, that the respondent terminated the contract without just cause, that the appellant is entitled to a compensation of 23 million naira, that the legal costs of these disputes and these proceedings be solely borne by the appellant in an amount that's deemed appropriate by this honorable panel. And with that, this brings our submission to a close. Thank you.
All right, thank you. The appellants from the University of Lagos. I would wish to invite my co-arbitrators, Ms. Pauline, Mr. Ayomide. Please, if you have any questions, this is the time.
Okay, hi. So I've got a couple of questions. My first question will have to do with the jurisdiction, or the question on jurisdiction. And so I will first ask that the clause being relied on by the appellant, is it an arbitration clause?
Yes, it is.
That's good. So the next question would be, do you think that opting to institute the case or the suit before the DRC instead of the NDRC nullifies the decision of the DRC?
Please, can you repeat your question, Mr. Arbitrator?
So I said, do you think that opting to institute the suit at the FIFA DRC instead of the NDRC nullifies the decision of the FIFA DRC, considering the fact that this is an arbitration clause?
All right. Thank you, Mr. Arbitrator. Our contention, yes, we do think that if the matter has been brought before the NDRC, they will have been able to, like, it included an employment-related dispute based in Nigeria and interpretation of Nigerian laws and everything, could have been able to do everything. But bringing it to that decision, bringing it to NDRC, bringing it to the before the NDRC, bringing it before the NDRC will have been better, as we've been able to like interpret the laws, be able to take a lot of things in consign. But then we recognize the de novo power of this court to review the matter on fact and the law.
Okay, so I will follow up with this question. Considering, what do you think? Do you think the nature of the transfer is an international transfer between the player and the club?
Sorry, Mr. Arbitrator, could you please repeat your question?
I said that, do you think that the transfer between the player and the club is of an international nature?
Yes, sir. It is of an international medium, as a respondent moved from an association in Uganda and came to Nigeria.
Correct. So, do you then think that the NDRC, which has jurisdiction over local matters, would be able to make a decision on an international issue?
Yes, Mr. Arbitrator.
Do
Yes,
you
Mr. Arbitrator.
Do you have any authority to back that up?
Yes, Mr. Arbitrator. So, looking at Article 22, paragraph 1B, stated that the FIFA DLC has jurisdiction over employment-related disputes between a player and a club of an international dimension. But then it provided that where the party have explicitly opted in writing for such disputes to be decided by a national dispute resolution chamber. So the fact that a dispute of an international dimension, the fact that the act provided that a dispute of an international dimension could be resolved by a national dispute resolution chamber shows that a national dispute resolution chamber can indeed resolve a dispute of an international dimension.
Okay, thank you very much. So my next question would then be on the non-payment of bonuses. So yeah, the non-payments and the partial payment of salaries. So my question would be, was there a disciplinary hearing for the player?
Mr. Arbitrator, we can't hear you.
Can you hear me now? Is it better now?
Yes, it's better now.
So was there a disciplinary hearing for the player before he got fined?
Okay, thank you, Mr. Arbitrator, for that question. The fact of the case did not state that a disciplinary hearing was given before he was fined, but instituting a disciplinary sanction in the player is part of the inherent right of the club. And we could see that each club has their own regulation, policy and code of conduct that provides for some actions if taken by the club if taken by the player, would entitle the club to institute a sanction on the player. And this is the same thing in this case. The respondent was absent from the court for an unauthorized period of time, and then it was a decision of the club to institute a fine to him as a form of a warning.
Wait, the fine was a form of a warning?
Yes, the fine was because as a result of the late resumption.
So, if I may ask, what are the options that were available to the club before the fine, and were any of them triggered at any point in time?
Okay, thank you, Mr. Arbitrator. Now, the option that could have been available to the club would be to have instituted a disciplinary proceeding, just the way you have said, or could have given a warning to the respondent. With respect to what I said earlier, it was the 500,000 was like a fine for the non-payment and not a warning. And the option that would have been was to institute a proceedings to hear the side of the respondent, and the other one would have been to give like a warning. But based on the fact of the case that we have, the only thing that the club did was to give a fine for the late resumption.
I agree, but however, don't you think that the player should also have been heard?
Yes, Mr. Arbitrator, we understand the plight that the player, there could have been an institution, disciplinary proceeding for the player to have been heard. But in this present case, this case is kind of crucial, special in the sense that the respondent's reason for being absent was as a result of informal communication from the team captain. The respondent on the side could have taken further steps to even inquire from the club management to be able to confirm the assertion or from the communication which you received. And also, we also try to buttress our points with the case of FC Natal and in the case of FC Natal and FIFA and all Nazil, where the panel mentioned some acts. If those acts has been taken by the club, for example, the registration of the player, signing of a new player, ostracizing the player, the club did not take any of these actions to be able to justify the informal communication by the team captain. Instead, the club CEO even reached out to the club, acting in good faith, to be able to inquire about his absence.
All right, my very last question will be on the calculation, your arguments on the calculation. And while understanding, taking into account the fact that there were several months left on the contract, do you not think that the bonuses as well should be taken into account? This is
right, thank you
also,
very
this is also considering the fact that while he was paid partially for 3 months, he was not paid any bonuses in that time.
All right, thank you very much, Mr. Arbitrator. Like we said, we definitely understand the position of the respondent, and we are not in any way saying that we are not responsible for the payment of bonuses, right? It's just the based on the law, bonuses are not ascertainable. Bonuses are not as concrete as salaries, and as seen in the moot facts, the appellant did its due diligence to pay promptly the salary of the respondent from the period specified. And so we are seeking a compensation, right? However, if this panel grants such compensation, we would seek that compensation be deducted, bonuses deducted from the compensation that we seek.
Thank you so much.
All right, thanks, Mr. Ayomide. Ms. Pauline?
Yes, please. I have a few questions for the applicants, and my first question would be about the jurisdiction of the NDRC. You do mention Article 101 of the FIFA that says that NDRCs can handle cases that are of international dimension. However, my question is, what certainty do you give us that the NDRC actually had jurisdiction to listen to this case within the confines of Article 101 that elaborates Article 22 of the FIFA DRC? I mean FIFA RSTP.
Thank you, Madam Arbitrator. Thank you, Madam Arbitrator, for that question. Article 72 of the NFF Statute 2021 provides for the establishment of the National Dispute Resolution Chamber of the Nigerian Football Federation. And it's important to note that FIFA Circular 1010 laid down the minimum requirements for an independent arbitration tribunal, such as the principle of parity, independent arbitration tribunal, right to fair hearing, and other principles that have been laid down. However, it is when this NDRC has been constituted, that is when all these things will be taken into consideration. And assuming the respondent has indeed approached the NFF, then all these things could have been taken into consideration, like both parties will have been able to appoint the arbitrators, be able to appoint the arbitrators that will hear the hearing, and also will be able to take in and also be able to ensure that there's equal representation on the part of the players and also on the part of the club.
Okay, thank you very much for that. Still on that issue, is there a guarantee that these conditions are actually fulfilled by the NFF arbitration panels or mediation panels? Are these in place already? And does that mean that the choice of does that mean that the decision that is made by the FIFA DRC is null and void because the NDRC was ignored. So the first question is, are these things in place? What constitutes of the arbitration panel to be able to entertain this matter?
Sorry,
Just like-
Madam Arbitrator, I could only get the whether all these things are in place. I could not get the second question.
I beg your pardon?
I said your question. Could you please repeat your question, Madam Arbitrator?
My question is, in the conditions that are set out in the Circular 101 that elaborates the article from the FIFA RSTP, does the NDRC satisfy these conditions? Are they in place? Does the NFF actually have panels to listen to the cases within the conditions that have been set in the circular and the regulations of FIFA?
Thank you, Madam Arbitrator, for that question. It's important to note that the fact of the case did not stipulate otherwise, whether the NFF is in place or not. But bringing it to the context of Nigeria, we recognize that although Article 72 of the NFF statute provides for the establishment of the NDRC is still not in place. But there are other avenue, local remedies that the respondent could have actually tried to rely on or to have utilized. We have the Player Statutes and Arbitral Committee. We also have the Arbitral Tribunal established under Article 68 of the NFF statute. And also when it comes to like specialized, we also have a specialized dispute resolution chamber, specialized dispute resolution framework, like the National Industrial Court that also hear employment related disputes between a player and a club. And which evidence is the case of Amarachi, Ukaigo, and Atlant's Club, where the NFL, where it was a National Industrial Court that held the dispute between the club and the player in that case.
Okay, thank you very much. I'll now go back to that. Moving to the second question is about the decision that was made by the FIFA DRC. Why do you believe that the FIFA DRC default decision was not given within the legal compliance? Why do you think that the default decision should not have been made?
Thank you, Madam Arbitrator, for that question. Now, based on the fact of the case, the respondents utilized the CEO's email address as a contact in the legal portal, and as a result of that, the CEO was hospitalized, and as a result of that, the appellant was unable to appear before the FIFA DRC. If the appellant had been able to appear before the DRC, they will have been able to object to his jurisdiction at first instance, and also be able to like bring on the fact, and also be able to state our own part of the fact of the case, and also be able to like state our reason for taking some certain action. And the amount that was given, the 40 million naira, would not have just been given for the respondent without an appropriate knowledge of the fact from both parties and argument from both parties, that to ensure a fair proceedings.
Okay, thank you very much. Now, I would like to ask a few specific questions. Did the CEO or the club receive notification that the claim had been filed at the FIFA legal portal?
Thank you, Madam Arbitrator. As clearly stated in the fact shows that the CEO was hospitalized at that time and was unable to check his email address to even confirm whether he received notification or not.
Okay, thank you very much. So, indeed, there was a notification to the CEO. Then my next question is, did they actually exhaust the options that are given within the procedure rules? Did they exhaust those options for them to be able to dispute the default judgment that was given?
Thank you, Madam Arbitrator. Now, based on the Based on the fact of the case, Madam Arbitrator, the fact of the case just stated to us that the CEO's email address was utilized as a respondent contact, and that the CEO, it was when the club was aware of this, that was when the club requested for the grounds of the FIFA DRC decision on the 31st of March 2025, and was also notified of it on the 30th of April 2025. And that is why the appellant is here before the CAS before CAS to be able to appeal against the decision that was given by the FIFA DRC.
Yes, please. I do acknowledge that. My question is, Willis, knowing that they could not respond to the current respondent who was the appellant at that time, did they actually exhaust their options before disputing the default judgment that they received, that you received? Okay, let me just make this easier, because I have a feeling you may not be getting the question correctly. While you say that the CEO's email is the one that was used as the correspondence for the respondent by that time at FIFA, and you do acknowledge there was actually notification to the CEO that the claim has been filed against the club, did the CEO or the club make any endeavors before the default notice before the default judgment was passed? Did they make any endeavors to avoid that, or did they actually utilize the options that are in place?
Thank you, Madam Arbitrator, for that question. The fact of the case, the facts before us did not state otherwise or provide that they actually tried to utilize anything. The only thing the fact of the case provides for us was that the appellant requested for the notification of the ground on the 31st of March 2025, and he received the notification of the ground on the 30th of April 2025, and then instituted the claim before the CAS.
Okay, thank you very much. Do you then recognize, this is my final question on this, do you then actually recognize the default notice that was passed by FIFA? If yes, no other options were utilized?
Yes, Madam Arbitrator, we recognize the default notice that was issued if there are no other option. And that is why we are trying to we want the CAS to invoke the noble power to be able to hear the case on fact and the law, so that justice can be given to the appellant, because the calculation of the 40 million naira was actually excessive and unjustified.
Okay, thank you very much. This is my last question. I would like to know why you believe that bonuses are not unpaid heirs of the player or the current respondent. Why you believe the bonuses should not be calculated under the unpaid heirs to the respondent in this case.
Thank you, Madam Arbitrator. It is our submission. We are not submitting that bonuses should not be given to the respondent. However, what we are trying to establish, based on the calculation of the 40 million naira award by the DRC, which was deemed excessive, is that salaries are more concrete than bonuses. We're not disputing bonuses, and we are not disputing that we had not paid the bonuses of the respondents, which is why I had stated earlier that in the event of an award by this honorable panel to the appellant for compensation, those bonuses should be deducted less the compensation that we seek.
Madam Arbitrator, just to buttress the points given by my co-counsel, the reason why we did not put bonuses part of the compensation is that bonuses are speculative. It is not easy. It is quite difficult for us to be able to know that, think that the certain amount of wins that the respondent was able to get in that season is going to get it in another season. So as a result of that, the speculative aspect of it is not easy for us to be able to quantify the amount of win we'll have gotten and be able to arrive at a calculation or to even add it to compensation. And that is why we did not include bonuses to be part of the compensation, because it is speculative.
Okay, still on the issue of unpaid heirs, I would like to know, I would like to ask why you believe that the notification sent by the respondent wasn't a proper notification before termination of contracts.
Thank you, Madam Arbitrator. Now, on the 30th of September 2024, the respondent sent a letter of demand for unpaid bonuses and salary deduction via WhatsApp. The contention of the appellant is that WhatsApp is not a recognized means, is not the established means of communication between the parties.
I would like to ask before you proceed, the channel that was used, does the club have access to it? Was it one of the forms of communication for the club?
All right. Thank you, Madam Arbitrator. Paragraph 5 of the moot fact shows that all communications, all negotiation and communication between NED and the CEO of Powerstar FC occurred via WhatsApp. However, the fact did not state that the employment contract was sent via WhatsApp. And also, in paragraph 9 of the fact shows that when the respondent wanted to get his letter to facilitate the visa application, the notice was also sent, but that notice was not sent via WhatsApp. And there's nothing in the fact that shows that the letter was indeed sent via WhatsApp. So we expected that in the absence of an established mode of communication between the parties, the appropriate means was for the respondent to either check the website of the club to be able to get the official email address of the club, or use the email address that was stated in the FIFA legal portal by the club.
Okay, thank you very much. That's all.
Thank you, Madam Arbitrator.
Thank you, Madam Arbitrator.
All right. Many thanks for your responses. So for now, you take a break off the mic and listen to what the respondents have in store for us. The respondents, you have 15 minutes starting now.
Good day, Mr. Arbitrator panel, honorable panel. Good day, Mr. President, honorable arbitral panel. My name is Fanakin Tum, and I'll be appearing alongside my co-counsel, Alexander Boro, and we shall be appearing for the respondents, in this case, Ned Kikomeko. The case before this arbitral panel is quite straightforward. It involves an employment contract between my client, Ned Kikomeko, and Powerstar FC, the appellant, where there was a series of fundamental breaches which justifies my client's unilateral termination of the contract between NED and Powerstar FC. We have distilled 4 issues which we shall be adumbrating. My co-counsel will be handling issue 1 and 2, and I will be handling issue 3 and 4. On the jurisdiction of this honorable arbitral panel, Article 58 of the 2024 edition of the FIFA Statutes, as well as Article 25 of the RSTP, established that appeals from the FIFA DRC can come before the CAS. Thus, this court has requisite jurisdiction to entertain this matter. Our request for relief is thus that this honorable arbitral panel should uphold the FIFA DRC decision of March 20, 2025, and rule that there was a series of fundamental breaches by Powerstar FC which justified the unilateral termination by Ned Kikomeko. We believe that the argument which we shall canvass demonstrate that our position is both fair and justified, and we fully trust in the integrity of this arbitral panel to come to a fair conclusion, and we appreciate your time and attention to this matter. We also would be willing to make compromises and allowances if advised by this arbitral panel to ensure that justice is fulfilled. I shall now be giving room for my co-counsel to adumbrate on issue 1 and 2.
Thank you very much, and good afternoon, panel of arbitrators. My name is Boro Alexander, and I will be handling issue 1 and 2 for the respondent. On the first issue, which is whether a valid and binding contract existed between NED and Powerstar FC, despite the lack of a signed counter copy. panel of arbitrators, our submission is in the positive and is backed by 3 salient standpoints. The first being the existence of a contract evident in the uploading of the player's information on TMS and issuance of the ITC. The second being the doctrine of estoppel and performance of the parties. And the third being that contract doesn't only rely on signatures to show their validity. Now, on the first issue, which is the existence of contracts due to the TMS and ITC issuance, looking at Article 5 Annex 3 of the FIFA RSTP, it provides that all international player transfers should be uploaded on the FIFA transfer matching system. And as paragraph 1 of the MUTFAT unequivocally provided that Ned is a Ugandan, hereby making him an international player. Moving down to FIFA RSTP Article 8, paragraph 2, Annex 3, which provides that one of the requirements to get an international transfer certificate is by uploading a valid contract between the player and the team. Now, paragraph 6 of the statement of fact shows that Power Stars FC entered the transfer instruction into the FIFA transfer matching system and further obtains NED's international transfer certificate. Unifying the provisions of FIFA RSTP Article 8.2 and the provisions of the MUTFAT paragraph 6, it is evident that since the ITC has been issued to Power Stars FC, a valid contract exists between both parties. The second standpoint, which is the doctrine of estoppel and performance of parties. Doctrine of estoppel can be summarized to mean when an individual is prevented from going back on his words on action, especially if another person has suffered an injury or reaped a benefit stemming from the words of action of the party. This doctrine has found its way into sports litigation in the CAS case of Beijing Rene FC and Marcin Roba, where CAS held that the conduct indicated acceptance of the agreement of terms, even though there was no formal contract signed. In addition, contracts do not only require signature to prove the validity. Section 91 of the Labour Act of Nigeria 2004 defines the contract of employment as an agreement, whether verbal or written, direct or implied, signed or unsigned. Looking at the case of Espindola da Silva and PSS Sleman, where the DRC outlined that an actual signature of the contract is not the sole element to determine whether there was a contract relationship between both parties or not. Instead, an employment contract can be materialized with the wish to be executed. For the provisions of the MUTFAT, particularly as paragraph 10 and 11, we saw on numerous occasions through the conduct of both parties that the terms of the contract were intended to be materialized. Panel of arbitrations. Pressing forward to my second issue, which is whether the FIFA DRC was competent to hear the dispute despite Article 12 of the contract providing exclusive jurisdiction to Nigeria's NDRC. Our submission is that the FIFA DRC had the jurisdiction to hear this matter, and our submission is backed up by the following standpoints. Firstly, the non-functionality of the NDRC in Nigeria, the right to litigation, and application of the blue pencil test. Now, on the non-functionality of the NDRC in Nigeria, Article 4, paragraph 3 of the NFF, as the Nigerian Football Federation statutes, provide that the official body for handling disputes and disciplinary matters are the NFF Disciplinary Committee and the NFF Disciplinary Board. There is no mention of the NDRC. However, Article 3, paragraph 1 of FIFA's NDRC recognition purposes gives member body the avenue to create a national dispute resolution chamber in line with the provisions of the FIFA circular number 1876 that gave detailed steps on how to ensure that a nation's NDRC is recognized by FIFA. And one of those mandatory steps is by writing to FIFA to verify the establishment of the NDRC. However, there's no evidence of Nigeria's NDRC writing to FIFA or operating as a functional body, hereby making the NDRC in Nigeria non-recognized, non-functional, and non-established by FIFA. Looking at the case of Amarachi Ukiegagbo and Aslan Football Club and others, where the court noted that the NFF statutes and the FIFA rules requiring arbitration through an internal dispute mechanism like the NDRC has not been domesticated or recognized under Nigerian law, and there was no established NDRC to handle football disputes domestically. No wonder majority, and even this particular case relating to football matters in Nigeria, are being resolved by the Nigeria Industrial Court. In the absence of an established or rather a functional NDRC, Article 22, paragraph 1b of FIFA RSTP gives the DRC power to hear employment-related disputes between a club and a player of an international dimension. As already argued and recognized by both counsels for both the appellants and respondents, NED is a player of international dimension, hereby giving the FIFA DRC the right to hear the matter at its first instance. On the final standpoint, which is the blue pencil test. The blue pencil test is a legal principle used to primarily determine whether an unenforceable or unforeseeable part of the contract can be removed without affecting the enforceability of the rest of the contract. In Beckett's Investment Management Limited and others, and Glenn Hall and others, the court gave the following grounds for the blue pencil test to be applied. Firstly, if the unenforceable provision can be removed without modifying the remaining wording of the contract. Secondly, if the remaining terms have adequate consideration. And thirdly, if the severance does not materially change the contractual purpose. Now, removing the unenforceable Article 12, rather Clause 12, which is the litigation cost from the contract, it does not disrupt or affect the consideration that's already been furnished for the remainder of the contract. Neither does it materially change the purpose of the contract. Now, this blue pencil test has also found its way to past litigation, where in Amazulu FC and Jacob, Finahes, Nambadi, and FIFA, where CAS held that was 15 of a player's contract that gave the club unilateral right to terminate the player's contract due to poor performance, was invalid and struck it out, while still giving room for the enforcement of the remaining clause in the contract. Panel of arbitrators, like argued earlier by counsel, the NDRC does not function in Nigeria and is not recognized by FIFA. And to limit NED's part to litigation to a non-functional court is to deny him his right to litigation and dispute resolution. It is our firm but humble submission that the FIFA DRC had the jurisdiction to hear this matter in the first instance, and that a valid contract exists between NED and Power Stars FC. We pray that this arbitration panel grant judgment in our favor. Thank you.
Moving on to the third issue, which states whether the unpaid performance bonuses and unjustified deduction of salary amounts to just cause which justifies NED's unilateral termination under the FIFA RSTP. I shall be adumbrating on this issue with the use of four standpoints. First is material breach of contract. Article 4 of NED's contract provided that he was entitled to 100,000 naira for every home win and 150,000 naira for every away win. NED featured in 30 matches in the first season and earned 14 home wins and 10 away wins per paragraph 11 of the statement of fact, which entitles him to 3.1 million in bonuses. However, Power Stars FC refused to pay these performance bonuses. In the case of FC Rubin Kazan and Dennis Kachok, the CS panel held that where there is contractual provisions for bonuses to be paid, then a club is bound to pay the bonuses as and when due. Furthermore, in the DRC decision of 14 October 21, the DRC also held that where there is a contractual provision for payment of performance bonuses, the football club has a responsibility and is bound to pay the performance bonuses. Moving on to the second standpoint, which is unlawful and unjustified salary reduction. NED in September 2024 was paid just 500,000 naira, which is just 50% of its agreed wage. In the case of Fenerbahce Football and Gregory Vandel, the CS held that any deduction of fine in wages must be backed by definite contractual provisions. A scan through the statement of fact shows no contractual provisions which gives the right for Power Stars FC to impose fines or wage deductions on my clients, Ned Kikumeko. Furthermore, in the case of FK Veles, Musta, and Frank Ikik, the sporting club wanted to deduct the salary of the player due to poor sporting results. However, the court held that where there is already a contractual provision as to payment of salary or bonuses, the club has a duty and is bound to adhere to it. On the third standpoint, which is lack of proper communication. Lack of proper communication was the fault of the club, Power Stars FC. As we can see in paragraph 5 and paragraph 14, the communications between Power Stars FC and Ned Kikumeko were all informal. At every point that the CEO of Power Stars FC wanted to communicate with Ned, they communicated with him via informal channels. It is not far-fetched that a voice call, which the appellant said is informal, would be relied on by Ned Kikumeko, given the fact that every single time that the club has communicated with Ned Kikumeko, it has been via informal communication channels. Moving on to the last standpoint, we state that this cumulative breaches justifies the unilateral termination. The FIFA commentary on the RSTP says establishes 3 elements which should be established before just cause can be established for unilateral termination of a contract. The first is sufficient breach of contractual obligations, and this was also held in the case of Galatasaray and Frank Ribery. The seriousness of the breach amounts to, firstly, the 3.1 unpaid bonuses, and secondly, unjustified salary reduction. The second element is that the breach is considered sufficiently serious that there is no reasonable expectation for the relationship to continue. This was also held in the case of Jean Philippe and Banias Football Sports Club. When Ned came back to the football club in September, he was not fairly paid. His bonuses remained unpaid, and there was no indication that Power Stars FC were going to treat him fairly or remedy the problems of deduction in salary or unpaid performance bonuses. The last element is the termination of the contract should always be a last resort, and this was also held in the case of Leandro da Silva and Sports Lisboa. Ned issued a default notice on the 30th of September 2024, requesting for his unpaid bonuses and the wage deductions. However, the club remained silent, stating that the communication channel was informal. But I would like to bring to the attention of this tribunal that paragraph 5 and paragraph 14 of the statement of fact, every communication the club, Power Stars FC, has had with Ned Kikumeko has always been informal. The fourth issue states whether the default decision by the FIFA DRC was procedurally valid and whether the compensation awarded was reasonable and enforceable. My first standpoint is that it was procedurally valid. Article 9 of the FIFA DRC procedural rule states that communication shall be sent through email or any other means provided by parties. Also, Article 12 of the procedural rules governing football tribunal states that communication should be sent to parties through any contact details provided by parties. We can see from the statement of fact that a notice was actually sent to the CEO of Power Stars FC. More so, in the DRC decision dated 11 July 2019, the FIFA DRC stated that once effective service is proved, they can be default decisions. As the appellant has admitted, there was actually a notice that was sent to the CEO of Power Stars FC. And given that this notice proves effective service, the default decision by the FIFA DRC is valid, it is procedurally valid. Moving on, the case of Delfino Pescara and Royal Standard League states that procedural default decision is valid when notice is sent correctly, and consequences for failure to respond relies on the party's internal management. This proves that the default decision by the FIFA DRC was valid. On the second standpoint, which is that the compensation award was reasonable and proportionate. In the case of FC Shakhtar Donetsk and Francelino da Silva, the court held that where compensation is being considered, the things to be considered by the arbitration panel are the remaining value of the contract, outstanding remuneration, bonus entitlement, consequential damages, and others. The compensation of 40 million is both proportionate and reasonable, taking into account, firstly, the deduction of 500,000 naira from Ned's monthly salary, the outstanding bonuses of 3.1 million, which points to the direct financial loss, the loss of future earnings for the remaining 24 months. In the case of FC Shakhtar Donetsk, like I mentioned earlier, compensation should also take into account the remaining value of the contract. Given that the contract has not expired, there are 24 months left in the contract, and 24 months at 1 million per month.
Your time is running down, so you must wind up in about 30 seconds.
I'm aware, Mr. Arbitrator. Thank you. Given the monthly deduction, the outstanding bonuses, and the residual contract value, the compensation by the DRC of 40 million naira is both reasonable and proportionate. Based on the arguments conversed on issue 3, our submission is that there was just cause which justified Ned's unilateral termination, and on issue 4, that firstly, the decision of the DRC was procedurally valid, and the compensation award given by the DRC was both reasonable and proportionate. And we pray that this honorable arbitral panel gives judgment in favor of the respondent. Thank you very much.
All right. Many thanks to the respondents for that wonderful submission. So I'll invite my colleagues to put the questions to the respondents, if any. We can start with Mr. Yomide.
Okay, thank you so much, Mr. Arbitrator. My first question would be that do you think that the deduction of salaries basically warrants the termination of contracts in this case? Or is it a ground for the termination of contract?
Thank you for your question, Mr. Arbitrator. Would like to point out that Ned Kikomeko, our client, sent a letter of demand on the 30th of September 2024 requesting for negotiations, requesting for his unpaid performance bonuses as well as the deduction in the salary. However, the CEO and Power Stars FC as a whole ignored his letter, stating that it was informal. But I would like to also bring to the attention of this arbitral panel that every communication that has existed between Ned Kikomeko and Power Stars FC has always been informal. We can see paragraph 5 and paragraph 14 of the statement of fact where the CEO reached out to Ned Kikomeko on WhatsApp, which is an informal communication channel. Given that our client, Ned Kikomeko, had sent a letter requesting for these problems to be remedied and they were ignored by the club, the institution of the case in the DRC was the last point of resort for our clients.
So my question is not necessarily about the formality or informality of the letter. I'm asking if non-payment of deduction of salary is a ground for termination of contract. This is considering the position of the RSTP.
Mr. Arbitrator, thank you very much for your question. The FIFA commentary on the RSTP, it states that there are 3 elements to be considered to justify or to amount to just cause which shall justify unilateral termination. And the 3 elements are firstly serious breach of contractual obligations. Firstly, the performance bonuses which was agreed upon was breached by Power Stars FC. Secondly, there was a deduction on salary which was not justified because deduction in salaries and fine ought to be backed by contractual provisions. Secondly, the second element is that there will be no reasonableness for the employment relationship to continue. Given that Ned Kikomeko had sent a letter dated 30 September 2024 requesting for remedies of this problem and it was ignored by Power Stars FC, there's no reasonableness for the employment relationships continue where the club, the football club, Power Stars FC, would continually breach the contractual obligations which it ought to abide by. And the last element is that the termination of the contract is a last resort. We have said previously that Ned Kikomeko sent a letter seeking to remedy these problems. However, they were ignored by Power Stars FC, and thus it was an action of last resort for him to terminate the contract, given that Power Stars FC continually over time kept breaching the contractual obligations.
So while I hear you, my first question would then be, is it not possible to argue or state that it was indeed the player who breached his own terms of the contract by not showing up to the club?
Thank you for your question, Mr. Arbitrator. Paragraph 5 and paragraph 14 of the statement of fact, we can see that every communication that existed between Ned Kikomeko and Power Stars FC were taken by informal means. They reached out to him on WhatsApp, and these are all informal channels. So it's not far-fetched that Ned would also rely on an informal channel, which is the team captain who said that the coach stated that Ned was no longer needed for the second season. Given that the power communication were taken on informal channels, it is not far-fetched that Ned will also rely on this informal channel.
However, while I hear you, my question would still be that being surplus to requirements or being told to be that one is surplus to requirements does not create a ground for one to not show up or fulfill their contractual obligations. Rather, in such a situation, you can argue that the player could have approached the club to sell him. So, is that not, in this case, the player also breaching clearly their own obligations to the club?
Thank you, Mr. Arbitrator. While we fully admit that our player is not without fault, we have stated that there were reasons for this fault. It was an oversight. Definitely, our client, Nefikomeko, should have reached out to the club to confirm the information he got. But like I said earlier, given that the power of communication was through informal channels, he was moved to believing that information that came from an informal channel. However, we do acknowledge that he was wrong to do that, and he should have taken due diligence to actually confirm from the club if the information he got from the team captain and the coach was correct. Like we earlier stated, we are willing to make compromises and allowances given that we know that our client is not without fault, and that is why we are here for this arbitration. We can always make compromises because we know that our client is not without fault.
All right, thank you so much. No questions from me.
All right. Many thanks for that, Mr. Ayonile. And I'll invite my colleague, Ms. Pauline, to finish any questions.
Yes, please. I just have a few questions. My question is in regards to the NDRC. The FIFA RSTP does recognize the NDRC to handle cases, even those that have an international dimension in them. So why do you believe that the NDRC should not have entertained this case to start with?
Thank you very much, Madam Arbitrator, for that question. Well, in order to properly answer the question, we need to look at the functionality of the NDRC. So the question is not about if the NDRC, or rather the case is not about if the NDRC has jurisdiction to hear the matter, or rather the fact that the NDRC has not been constituted, nor is it recognized by FIFA DRC. Hence, there is no NDRC to hear the matter. And the next proper channel, as seen in FIFA RSTP, that gives room for litigation between a player of international dimension and a club in resolving disputes, is the FIFA DRC. So also looking at the case of the Raya Club Athletic case, where the court has held that if the Moroccan NDRC does not meet the proper standard, then the FIFA DRC has the right to hear the matter. So considering that the Nigeria NDRC has not been constituted, hereby failing to meet the proper standard, it can't hear the matter, and the next proper avenue is the FIFA DRC.
Okay, thank you very much. I would like to also ask, why do you believe that the default judgments or the default decision that was given by FIFA should actually be enforced?
Thank you very much, Madam Secretary. For the first point of call is to note that FIFA DRC is competent and has jurisdiction to hear the matter. It's a cause that has the jurisdiction to hear the matter, and the decision is binding on both parties. So the judgment by FIFA DRC, although there's room for the appellate court, which is the CAS, and that's why we are here today, but the decision by the FIFA DRC should not be overturned due to lack of jurisdiction.
I still insist on my question. My question is, why do you think the default judgment is actually binding? Why do you think the default judgment was issued properly?
So on the first ground being that the FIFA DRC has jurisdiction, second ground being on its merits, the proper procedures were followed, both parties were given proper notice, and the merit of the decision is enough grounds for the decision by the FIFA DRC to be binding on the parties.
Yes, we do. I do recognize that, and fellow arbitrators do recognize that. However, my question still stands. Yes, both parties received notification of their claim, but then why do you still think that despite reception of the claim by the respondent, why do you believe that this default decision is enforceable and took its right channels or process?
Now, arbitrator, can you please rephrase the question?
Why do you think that the FIFA DRC, why do you believe the FIFA DRC issued the decision in the right channels or the right process?
Thank you for that question, Madam Arbitrator. Like my co-counsel has established for us now, the NDRC, the one for Nigeria, is not functional. And so this invests jurisdiction on the FIFA DRC to actually entertain the matter. Secondly, like he said, the procedures were followed. The FIFA DRC procedural rules, as well as the procedural rules governing football tribunal, states that a default decision shall be valid where effective service is proved, that is, notice is given to both parties, and then if a party decides to not appear before the FIFA DRC, the consequences is to be borne by that party, given that effective service was actually proved. The appellants themselves have already admitted that they actually received the notice, so effective service was actually given. Thus, the procedures before the FIFA DRC should give a default decision was actually followed, and this makes the decision given by the DRC procedurally valid, given that it had jurisdiction and effective service was proven.
Yes, yes. Both parties do agree that the respondent actually received the correspondence from FIFA that the player had filed a claim against them. And I still insist, because the appellants tell us that the default judgment did not take proper process. And I'm asking you again, according to the FIFA DRC procedures, why do you think that the default decision took a proper process to be arrived at?
Based on the information which is available to us, given to us by the statement
I
of
beg
fact.
it. And let me interrupt you. Just let me interrupt you. Yes, the facts, we are aware of the facts, but the question is very specific to the FIFA DRC process. And that is why I still insist. Why do you believe that the default decision that was given by the FIFA DRC took its proper procedures and its proper process? And because if you're able to answer that, that means this appeal does not stand cause before the CAS.
Sorry, Madam Arbitrator, can you reiterate the last thing you
This
said?
question, I would like to ask this for the last time. This question is very specific on the FIFA DRC procedures, because the appellant tells you that despite the respondent receiving the notification that you see the player has filed a claim, despite them receiving the notification that a claim has been filed against them, they still believe that the default decision should not have been given, and it did not take proper process. And I am asking you as the respondents to please indulge us as to why you believe that FIFA DRC took due process to give the default decision.
Thank you for that question, Madam Arbitrator. I would like to make 2 points. Firstly, by virtue of the information given to us by the statement of fact.
Again, I would like to interrupt. That this question is not about the facts of the case. This question is a legal question in reference to the FIFA DRC process or procedures. So again, why do you think that the FIFA DRC actually took the right process or procedures to give the default decision that is actually being disputed before this case? If you're able to answer that question in the affirmative, that means this case should not be before the case.
Thank you, Madam Arbitrator. I think, firstly, I would like to state that it is right that he who assets should prove. If the appellants are saying that the FIFA DRC does not have, or the FIFA DRC default decision was not procedurally valid, they have the burden of proving, given that they are certain that the decision was actually not procedurally valid.
Okay, thank you for that response. Equally, the respondent also bears a burden of proof in regard to a previous decision that has been disputed before the CAS. Regardless, I do appreciate your responses to my question. Thank you.
Thank you, Madam Administrator.
All right. Many thanks for the questions, the arbitrators. So I'd like to take it back to the University of Lagos. You have 5 minutes for your rebuttal, and they should be limited to what has been said by the respondents only. So you shouldn't add in anything else other than rebutting what has been said by the respondents. So you have 5 minutes starting now.
Thank you, Mr. Arbitrator. Thank you, members of the tribunal. Firstly, on the issue of jurisdiction, the respondent made mention that there was no mention of NDLC and the NFF statute. However, Article 72 of the NFF statute provides for the establishment of a National Dispute Resolution Chamber within the NFF. And another point to note is that the respondent also based their argument on the non-functionality of the NFF based on the fact that they've not been recognized by FIFA. However, Article 10 of the NDLC principles stipulates that the recognition principle will only apply to cases brought before 1st January 2025. This case was actually brought before FIFA DRC on the 21st of October 2024. So the NDLC principle does not apply in this case. On the issue of just cause, the first on bonuses, we've been able to establish that bonuses are considered to be overdue payables under Article 12 BIS and does not constitute justification, and does not constitute unilateral termination of a contract. And also in the case of Akisan Veladini and Daniel Chili, it has been held in that case that bonuses does not constitute salary and cannot justify unilateral termination under Article 14 BIS. With respect to deduction, the deduction was justifiable because the respondent was absent for the whole of August, and the respondent cannot rely on the informal communication by the team captain, as we have held so far that the appellant has never represented the respondent to give any of his actions or has never held out the respondent to give any of his actions to the respondent before, so as to be able to constitute ostensible authority. To further buttress our point, we've been able to lay down that there are some actions, if those actions have been taken by the club, could have actually corroborated the informal communication. These are the registration of the player, signing of a new player, ostracizing of the player. None of this happened in this case to the respondent to be able to show that the deduction was justifiable. I will leave the floor to my co-counsel to address the compensation part.
Thank you very much, Honorable Panel. I will be rebutting on just one point. The respondent said that the 40 million naira award by the DRC is proportionate, to which we rebut that award is disproportionate and does not show any element of fairness. We submit that it is contrary to fairness, it is excessive, and that it should be set aside by this honorable panel. We submit that the respondent's calculation cannot possibly reflect an accurate measure for compensation. It is almost as though the respondent is trying to mislead this honorable tribunal in its calculation. First, for bonuses, the respondent has calculated the sum of 3.1 million naira for bonuses covering 14 home wins and 10 away wins. In calculation of this, 14 home wins amount to 1.4 million naira, which is 100,000 naira times 14, and the 10 away wins amount to 1.5 million naira, which is a sum of 150,000 naira times 10. And if my maths is correct, it gives me a total of 2.9 million naira in bonuses. Furthermore, the respondent has relied on CAS jurisprudence in their memorial in page 29 and relies on the case of Matuzalem and Article 17 of the RSTP to justify the 40 million naira award. We claim we submit, rather, honorable panel, that if this claim is on the positive interest principle, it does not justify fairness, as the respondent did not, the respondent being Ned Kikomeko, did not clearly mitigate his losses in any way, and that there should be evidence of future earnings or detriment to justify such amount of 40 million naira, and bonuses and even the residual amount of the salary cannot possibly amount to 40 million naira. And so we submit that this honorable panel deem that that 40 million naira award is excessive and should be set aside. Thank you very much.
All right. Thanks to the appellants, the respondents, over to you. 5 minutes responding to only what the appellants have said in their rebuttal. Your time starts now.
Thank you very much, panel arbitrators. Once again, it's I, Boro Alexander. Now, on the issue of the Section 72 of the NFF that spoke about NDRC. However, it should be noted that regardless of the provision of Section 72, the NDRC has not been constituted, as highlighted in the Amarachi Ukiagbo and Hasland case, and also in the Raya Club Athletic case, where the CAS established that if the Morocco board, which in that case was the national NDRC in dispute, had not made the proper standard, then they will lack the jurisdiction to hear the matter. And regardless of what Section 72 of the NFF statute says on the creation of the NDRC, such dispute resolution chamber has not been properly constituted, neither has it been recognized by FIFA. And as highlighted in Amarachi and Ukiagbo case, and in a number of legal commentary like OM, Atuyebi, SCM, in an article for Omaplex Law Firm dated July 9, 2024, that noted, and I quote, "It's sad to state that the Nigeria has not established the NDRC to the resolution to help resolve football disputes in Nigeria." On panel of arbitrators, it's quite evident that the NDRC does not function and has not been constituted in Nigeria. Hereby, by virtue of Article 22, Paragraph 1 of the FIFA ROSTP, the next course of action for NED is the FIFA DRC. I'll now be yielding the floor to my co-counsel to handle rebuttals on the remaining points.
Thank you very much, arbitrators. I shall be giving the final rebuttal. The appellant hinged their argument on the fact that there is no, on the assertion that there is no just cause on Article 14 BIS of the FIFA RSTP. However, I would like to state that Article 14 BIS creates another situation for just cause. It is not the only situation given by the use of also in the article provisions. So it is not the only element, it is not the only provision that can establish just cause. However, the appellant stated that that is only the provision that can establish just cause where a player for a football club is not paid his salary for 2 months or more than 2 months. However, it is just another provision. It's not the only provision which would establish just cause. Thank you very much. This will conclude the argument.
All right. Thank you for the respondents for that precise response. So at this point, we are on the final bend of this session, and I'll be giving a bit of feedback, probably in a minute or two, and then you will hand it over back to the organizers who will guide on the way forward. But before my co-arbitrators come in, I would wish to congratulate you. You've done very, very well. I can say it's very, very impressive. You have good knowledge of the facts, good knowledge of the law, not only at FIFA level, but also the suitable facts and the law and the positions in Nigeria. It's very good that when you go to the international level, you don't forget the positions back at home. So juxtaposing what is the international level and fitting it into the international dimension is something that is very, very commendable, and that is very, very good to hear, and also good to see that you put in the cases. What I would probably add on to you to sharpen you better is that in those cases, especially if you have, because you're lucky that this session will let you go on and you're not interrupted. But if you're not interrupted, it's very good that the cases that you choose, at least 1 or 2, you can be able to show us why you think it's relevant to this case, and what are the factual similarities, so that we can be able to connect, to plug into the facts at hand into the case that you're giving us. I know it may give you a bit of time, but if you do your homework very well, you could still probably a minute or two to just fit the case that you have given us, to fit them into the facts that you're dealing with. That would even make you super impressive. But kindly let us hear from my co-arbitrators on the feedback that they have to give you from the session before we take it back to FLAM. I'll start with Mr. Ayomide.
Yeah, I think, to be honest, you all did well. You did great. In terms of answering the questions, I think though that it's important to be more direct. There were certain questions that we had to ask like twice, thrice, because you just weren't as direct as we needed you to be. So I would advise to try as much as you can to be as direct as possible. Don't necessarily beat around the bush. We also know what we're looking for, what we want to hear. And so just be as direct as you can. And I would also add that while you are following the facts, it's also very important to stay abreast of happenings in and around that subject area, because there's some things that you would give me an example, or you would say some arguments that you would make, and I can almost cite you two to three different examples that have happened in real life. So you have the facts, yes, it's very good, but also have some extra knowledge that you can use to back up the facts that you have, in case you get asked certain questions like you were asked today. And I mean, some answers were good, some were could use some work, but you guys did excellently well, and congratulations for coming this far, to be honest.
Thank you, Miss Pauline.
Thank you very much. Well, my remarks are just about acquainting yourselves with the procedures that are involved within the CAS and the FIFA DRC, because before you can to the CAS, you must be aware of what the FIFA procedures are and also what the CAS procedures are, but also specifically to this case, because one of the contentions is that, oh, you see, the default judgment was given, but we don't recognize it. Now, this is basically a procedure issue. For you to be able to argue that, you must be acquainted with how the procedures at FIFA DRC actually take form. So without that, you're not able to satisfy the CAS, and precisely that means CAS may not actually have the rights to entertain the case, simply because you don't prove to CAS why you think the procedures at CAS were rightly followed, and also why you think, even when they were rightly followed, the decision is actually binding. So if you're able to show contrary of that, or to show that all these are satisfied, if you're not able to do so, for example, in the case of the respondent, the applicant, if you're able to show, okay, there's the procedures were not properly followed, you're able to then show that CAS can actually entertain this, because CAS doesn't have to throw out this case based on its own procedures, but also based on the FIFA procedures. If proper procedures were actually followed, and then the other issues are answered in the affirmative, that means there is no need for FIFA, for the CAS to entertain the appeal that is being brought from FIFA. So that is why it's very important for you to acquaint yourself with those laws, because they're very important in your arguments, and also to be able to prove your statements, you must be able to argue them. But also, most importantly, it is not just the appellant that actually has a burden of proof. Even the respondent has a burden that they bear. And in this case, they have a burden to show us why they believe that the decision that was given by the DRC is a binding decision, and that everything was followed to the pin, so that the CAS can actually be throughout the the appeal has been brought by the applicants. Besides that, I think it's important for you to always prepare yourself for questions that are going to be a bit repetitive, because these questions are not just examining your content, but also they are not just examining your content, but your logic. Because for example, the question that I last asked, it wasn't about facts. It was very repetitive for me because it was examining your knowledge of the laws that govern the FIFA DRC. So with that, I don't think I have anything else that I would like to add. However, I would like to credit you for responding to the questions that we had as a panel. And moving forward, please go on with that confidence. Whichever team proceeds from this round, do move on with that confidence, but also bear in mind whatever takeaways I've given you. Thank you.
Right. Thanks, Ms. Pauline, and thanks, Ms. Ayomide, and thank you to the appellants and respondents of the day. So I'd like to give it back to our organizers.
Sure, thank you very much, the chairman of the panel, Mr. Timothy Kaija, and our arbitrators, Ms. Pauline Baza and Mr. Ayomide Ribake, the participants to University of Lagos and the University of Benin. Quite an exciting session. On the backside, this way I keep enjoying the conversations that keep going through. Very amazing. The questions too, learning process as budding lawyers, as budding sports lawyers, take this as a process. I can't re-emphasize more on what the arbitrators themselves have been able to say or comment with regard to the processes of understanding these dealings. Indeed, we shall definitely communicate which team will progress from this particular round after all the rounds are done. But from FLAM, I would like to thank all of you and wish you a wonderful rest of the day and a rest of the week. Thank you.
Thank you.
Cheers.
Thank you very much.
Thank you.
Thank you.
Thank you too.